Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamblett Kerrigan. I've been practicing law in New Hampshire for approximately 36 years, and in Massachusetts, Commonwealth of Massachusetts, I'm licensed to practice there for about 28 years. And during that time, I've had frequent business clients of mine, I represent a fair amount of business clients and executives, ask the question of, can I discipline a employee that says they have a mental disability for performance issues? And the answer is yes. I'm particularly going to be focusing in on this today on New Hampshire, but both New Hampshire and Massachusetts have disability discrimination laws, and federal laws are also, the American with Disabilities Act is present, and it prevents you from taking actions against people who are disabled for one, overt actions because you perceive them to have a disability or they actually have a disability, and that includes mental health issues, and providing a reasonable accommodation for them to be able to do their job if they have a disability. And those are the laws in New Hampshire and in Massachusetts and the federal laws that are out there, and they're important laws to protect people. But being a jerk is not a protected class. And when somebody has a performance issue, they may have it might be a component of mental health issues, but they go and strike out verbally or physically with an employee. They do something else. I've had a situation where somebody said because they were manic and they're manic depressive, because they had manic depressive disorder, they were stealing from the employer, and that's why they were doing it. Those types of conducts, you want to focus in on those conduct with your employee, and one circumstance itself might be enough to fire the person, but if it's a situation where there's some chronic issues and one isn't enough, you want to make sure you document it, and it's all about performance. It's not about, I think you're out of control. You don't want to say something like that. You want to say, you shouldn't have hit that person. You shouldn't have yelled at this person. You shouldn't have stolen from the company. And those are the reasons it's performance-based that you want to focus in on, and because that's exactly what you're doing. You're not hopefully, as an employer, you're not in a situation where you're concerned about the person's mental health and you just want them gone because you think they might be a problem in the future. You're dealing with those misconduct issues. And again, I've had a federal court judge say that in a social setting once, in a legal social setting, that being a jerk is not a protected class. You can't go and claim that you're depressed or you have manic depressive disorder or some other legitimate mental health issue, and that's a justification for you to be abusive to your customers, to your co-employees, to your boss. Under those circumstances, you can't. Now, what I mean by abusive, I want to focus in on too. Under federal law, you have the right to complain in the workplace. You have the right to complain with fellow employees. You get the right to complain to the boss. And if you think something is illegal, you have some what's called whistleblower protection. So you have those rights to actually do a complaint. I'm talking about how they do it. So they go and scream at their fellow employee. They tell the employee that they're going to get them. They're going to, when they least expect it, I'm going to get you. Those types of conduct you do not have to put up with. And you should talk to an attorney. You should address the issues, and the example of if somebody's threatening that I'm going to get you, and maybe it's even implying some violence involved, their job might be terminated effective immediately without any type of warning associated with it. If they say, well, it's not my fault, I was erratic because of my medications, or I was some other reason on this situation, you can look at the circumstances, and maybe there is a circumstance where you want to consider giving them an opportunity. But if it's something where they struck out at somebody, or they really threatened that they were going to kill the person or beat them up, and they say, well, my medication was off, it's still the conduct that you can't unscramble that egg. That misconduct was such of a nature that there is some protection for you under the disability laws. You're actually not taking any adverse action against the person because of their mental health issue. It's because of what they did. And in those circumstances, you do have some rights there. Again, under some circumstances, you might want to consider talking to an attorney about, is there some type of measures that they have? Is this a one-off where they had a new medication and it was the doctor and them didn't have a chance to get it right, and they've been a good employee otherwise? Maybe you're going to consider giving that person another opportunity, but you're going to explain to them that actions matter and consequences resulting of that are going to be taken. So I'm Dan Marr. I'm Hamblett Kerrigan here in Nashua, New Hampshire at 603-883-5501. I've represented a number of all types of businesses over the years dealing with employment matters, both in New Hampshire and Massachusetts. And I'm happy to talk to you if the opportunity arises. Just maybe sometimes bounce ideas off of how to do things the right way. I have clients that call me regularly on those types of situations. So 603-883-5501, Dan Marr. You can check out our website too. I have weekly blogs there at nashualaw.com. That's nashualaw.com. Look forward to working with you if the opportunity arises. Thank you.